I believe we're ready to begin this morning. We're on day 2 of the hearing in the matter OCC 25875, and we have reached our second public comment opportunity. I believe there's someone, Melissa Troutman, perhaps on the platform.
Yes, good morning. Can you hear me?
Yes, thank you. Would you spell your first and last name, please?
Yes, it's Melissa Troutman, MELISSA TROUTMAN.
Do you swear or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Yeah, good morning. My name is Melissa Troutman, and I'm the Climate and Health Advocate for Wild Earth Guardians. I want to highlight 2 serious concerns with OCD's proposed regulatory scheme for Class 6 CO2 injection wells. The first is the capacity issue related to staffing and funding for the program, particularly as Guardian stressed in its opening remarks, the post-permitting oversight and enforcement phase. Fast-tracking the permitting of Class 6 injection wells intended for permanent CO2 storage without a long-term plan to ensure adequate staffing and funding for comprehensive oversight is an unacceptable hope for the best approach that puts the health, environment, and lives of New Mexicans at risk for the sake of OCD's desire for regulatory efficiency. For this reason, the Commission should deny OCD's rulemaking petition. Guardian's second cause for concern with fast-tracking the permitting of Class 6 injection wells stems from OCD's continuing struggle to oversee New Mexico's existing oil and gas waste system, including injection wells, a system characterized by thousands of spills, recurring pollution, and limited enforcement. The scale of OCD's failure to effectively manage its existing regulatory programs is staggering. Just 2 weeks ago, Wild Earth Guardians released its Q2 Waste Watch analysis, documenting 17,373 reported oil and gas spills during the first half of this year. That's an average of 96 spills every day, or roughly 1 reported spill every 15 minutes. Operators reported spilling more than 4.5 million gallons of liquid oil and gas waste in the first 6 months of this year, with more than 1.5 million gallons of those lost into New Mexico's surrounding soil and waterways. The report also found that enforcement remains limited despite tens of thousands of reported spills each year, many of which are happening at injection wells. Before OCD rushes to take on responsibility for permanently storing industrial carbon waste underground through a new regulatory program, it needs to first demonstrate to New Mexicans and the Commission that it can effectively oversee the oil and gas waste system it already regulates. Unless and until OCD does this and reverses its failing track record on oversight and enforcement, the Commission cannot allow the division to take on yet another regulatory program that is unable to fully oversee and enforce. Thank you.
Thank you, Ms. Troutman. Is there anyone else on the platform who would like to offer public comment at this time? The next opportunity will be at 9 o'clock tomorrow morning. I see Andrew Forks Goodmanson from Earthworks. Let's see here. I think you need to allow his microphone, Sheila.
Hi, can you hear me?
Yes, thank you. Would you spell your first and last names, please?
Yes, only if it doesn't count against my 3 minutes.
No.
My name is Andrew Forkus Goodmanson. It's Andrew Forkus Goodmanson. It's Forkes hyphen Gudmundson.
Do you swear or affirm to tell the truth?
Yes, I do.
Please go ahead.
Thank you. My name is Andrew Forkus Goodmanson. I'm the Senior Manager for State Policy at Earthworks. In my role, I work on a variety of issues across New Mexico, Colorado, Pennsylvania, and Texas related to the oil and gas industry and other associated projects. And I wanted to speak to you today about a specific issue that many of those states are grappling with, and that's bonding in the context of these Class 6 well proposals. Bonding is important because whatever you think of the idea of carbon sequestration, these projects will eventually close and will eventually need to be cleaned up and remediated, and that will always cost money. Bonding is the tool or a tool that states use to ensure that taxpayers aren't left on the hook paying for all of those cleanup costs. A bond, at its most basic, is a promise to pay, but most importantly, it's a promise by someone else to pay. In the oil and gas world or any of the similar spaces, bonds are used to make sure that if an operator goes bankrupt or is for some other reason unable to pay for the cleanup costs at the end of a site's life, the bonding company will pay instead. Self-bonding or self-insuring completely defeats the purpose of bonding. It takes the idea of the bond and turns it literally into just a promise to pay, but without the vitally important third-party guarantee. Self-bonding never works. These projects are far too expensive and far too complex to clean up to the point where they will require decades of ongoing monitoring and maintenance to rely on what is functionally a pinky promise. We watched self-bonding fail before. In the coal industry, 3 of the largest operators went bankrupt in 2015, 2016 after self-bonding hundreds of millions of dollars of remediation obligations, leaving taxpayers holding the bag. We also just wrapped up a years-long process to fix the broken bonding system at the Oil Conservation Division for oil and gas companies that allowed them to avoid responsibility for cleaning up the wells at their end of their lifespan. Let's make sure we learn from these lessons from the past and put our best foot forward as the state grapples with these Class 6 well proposals. I strongly urge you to remove self-bonding as an option for these projects and require instead real bonding with real independent financial instruments and make sure that these projects are managed well through the end of their lifespan. Thank you very much for your consideration and for your work on these important rules.
Thank you very much. Is there anyone else on the platform who'd like to offer non-technical public comment at this time? The next opportunity is 9 a.m. tomorrow. Anyone else on the platform, Sheila?
No, I don't see anybody else.
All right. Is there anyone in the room who'd like to offer public comment? No. All right, we're going to move back to the technical case then. When we broke yesterday afternoon, we had heard from all of the division's witnesses, and the division chose to create 2 panels for the purposes of cross-examination. Is there anything before I invite the cross-examination?
Not at this time, Madam Hearing Officer.
All righty. So we have Dr. Khaniani and Dr. Wong. Let's see, Mr. Tucker, if you would.
Thank you. Oxy actually does not have any questions for this panel. Thank you very much.
All right, thank you. Namoga, Ms. Gutierrez, are you on the platform?
I am. Good morning. No cross-exam from us either. Thank you.
All right, thank you. Ms. O'Grady?
Good morning, Madam Hearing Officer. Let me have just one moment, please, to pull up my notes. Apologies.
And then you have an hour.
Thank you. Good morning. My name is Morgan O'Grady, and I represent the conservation groups. How are you guys today?
Good morning. I'm doing okay. Thank you.
Yeah, I'm doing okay too.
Good. Thank you so much. Dr. Khaniani, you specified on your demonstrative slide 6 that Class 6 applicants must characterize known or suspected faults or fractures, correct?
Correct.
And you specified in your direct testimony on page 3 that faults are heavily scrutinized based on 3D seismic data because they can act as a natural pipeline to allow movement of fluids and potentially underground sources of drinking water contamination. Yes?
Yes.
Is it possible that there could be unknown faults in the area?
It is definitely possible that there will, because the data that we have, 3D seismic data, we have uncertainty in the event. It is also the possibility because there is an uncertainty always, some sort of uncertainty, finding all of the fault.
That makes sense. Thank you. But just to clarify, OCD witnesses do oppose conservation group's proposal that would require 3D seismic characterization of the full AOR?
Can you repeat that again?
Of course. OCD witnesses oppose conservation group's proposal that would require 3D seismic characterization of the full area of review.
What is that based on?
I can pull up testimony. Give me just a moment. Thank you. Dr. Schnaar's testimony on rebuttal testimony on page 17 states that mandatory 3D seismic characterization may be necessary and appropriate in some cases, and in others may be infeasible or provide little additional value while significantly increasing project costs and permitting timelines. Are you familiar with this testimony of his?
Madam Hearing Officer, Dr. Khaniani did not prepare Dr. Schnaar's rebuttal testimony, so if he's prepared to answer questions about the 3D seismic and modeling, et cetera. So soft objection, I believe it may be outside the scope of his testimony.
Yeah, thank you, Ms. O'Grady.
That's fair. Thank you. So I guess as a follow-up question, Dr. Khaniani, since there is uncertainty in the modeling and there may be unknown faults in the area of review or potential area of review, would you support full modeling 3D seismic modeling of the full area to ensure that there are no unknown faults?
Definitely, I support use of the full characterization and use all of the available resources we have. I also want to have a comment about some area they may have less uncertainty regarding the existing default because they may have less tectonical tension, and the present default may be less than in some other areas. So maybe that helps. But definitely we should have the full characterization of study with all of the possible data that we can get and analyze the subsurface to ensure the safety.
Okay, thank you. Another question for you, Dr. Khaniani. You define the pressure front on your demonstrative slide 4 as being how injection pressure spreads beyond the plume.
Correct.
Does the pressure front have an obvious edge or end?
No, it's always has a transition. It's based on the diffusion equation. It's not like a straight line. Yeah.
Thank you. So could two operators potentially define that pressure front and where it stops causing endangerment to underground sources of drinking water? Could two operators define that differently?
Almost, they will have some certainty in the boundary, but they will be very close.
Another question for you. Plumes migrate once they're underground, and modeling carries some uncertainty.
Sure.
And there's fault modeling before a permit is issued.
Yes.
Could a permit be approved in an area with a known fault?
With an unknown fault?
With a known fault.
Okay, so it has different process. The first one is identifying of the fault, and the next step is to perform numerical modeling. And in the numerical modeling, we usually simulate the plume extension during several years. It depends on the length of the project. And you anticipate, based on the risk, you anticipate if the fault, if your plume reaches to the fault, even if reaches to the fault, does it migrate? And those are not like a straight answer I can't give.
No, that's helpful. Thank you. So the likelihood of the plume to reach a fault and activate that fault is based on the modeling.
Yes, based on the modeling in different aspects. One is reservoir engineering, like fluid flow through the porous media, how much it reaches. The second one is, okay, what pressure you are activating to the surface of the fault. And you also need to understand the fault system itself. And if the pressure activation is sufficient to activate the fault, and if it is sufficient to activate the fault, then what is the slippage potential? And yes, that is the process.
Given the uncertainty in modeling, is it possible the plume could migrate in an unexpected direction or manner and encounter a fault and activate it unexpectedly?
It is if the data set that we have, because this is about class 6, if the data set that we have has uncertainty and the uncertainty is updated during the time, and then you can predict if your information is wrong or is false, then you can predict a plume in a obviously in a wrong position that it should be. So it depends on the data set that you have. You predict the data based on, you predict the result based on the data that you have. I would say it depends on the quality of your data and the structure of subsurface as well.
Is it possible that the data could be, you could be gathering data, but you might not hit that first 2-year mark where you have to review your area of review? And so you may have new data that would inform your modeling, but you haven't shifted your area of review and your planning yet?
No, can you specify about this?
Yeah, sorry, I didn't ask that very clearly. You say that you predict the result based on the data that you have. And so whether the certainty of your modeling depends on the quality of your data and the structure of your modeling.
Yes.
However, is it correct that an area of review is not first reevaluated until after 2 years under the division's proposals?
This is in general, I have no comment on that because everything can be possible. But it depends how we gather the data initially.
Okay, thank you. Dr. Khaniani, you state that third-party verification is not necessary because both the division and the public have the opportunity to review the permit application and the technical details.
Correct.
Are you aware that permit applications are redacted prior to circulation to the public during the public comment period?
Can you explain more about that?
Yes, so would it surprise you that some information in a permit may be claimed by that permit applicant as confidential information that they do not want to have released to the public, so that information would be blacked out or removed from the application before it is circulated?
I'm not sure about that one.
If some information were removed from the permit application or redacted from the permit application before circulation to the public, could a member of the public evaluate the technical merits of the modeling?
So based on the permit application, usually they place a lot of information. I believe that is necessary to evaluate the process that has been done by the permit. That's what I can say.
Thank you.
Yeah.
Okay, that's all that I have for you guys today. Thank you so much. Really appreciate both of your time.
Thank you.
Thank you, Ms. O'Grady. Mr. Pavlik, do you have questions? Are you on the platform?
Yes, good morning. I do. Morning, Dr. Khaniani, Dr. Wong. My name is Zach Pavlik. I represent the Center for Biological Diversity. Really appreciate your time this morning. I think these questions will probably be best directed at Dr. Khaniani, but yeah, we'll start there and see. We might have a few that will be relevant to you as well, Dr. Wong. So in your direct testimony, I'm going to start with Dr. Wong, just based on your direct testimony. In your direct testimony, you outline what an injection zone is in the classics context. And I'm curious, in a historic oil and gas field, where reservoirs serve as a confining zone for permanent storage of CO2? And sorry, if
could we
that comes from, sorry, go ahead.
Could we ask the council to repeat the question, because it didn't come through very clearly for us?
It was a
Oh,
little
sure.
choppy, Mr. Pavlik.
Let me see if I can adjust my sound here. Okay, yes, Dr. Wong, in your direct testimony, you outline what an injection zone is in the Class 6 context. Can a historic oil and gas field or reservoir serve as a confining zone for permanent storage of CO2?
So what I'm hearing is, does the oil and gas production zone can be served as the injection zone? Is that correct?
Yes, in this case, I'm curious about a former oil and gas production zone.
That's the depleted oil and gas production zone, right? If my
Correct.
understanding is right. Technically, yes.
Okay. And in your opinion, is this depleted oil or gas production zone a strong location to site a Class 6 injection well?
Could you please repeat your question? Sorry.
Sure. Is it, are you able, is the audio any better? I can try taking my headphones out if it's an audio problem.
That might improve things.
Okay. Thank you. Okay, is that any better?
It is less scratchy. Yeah. Just increase the volume.
Sorry about this. I'll have to get this sorted. Yeah, so Dr. Wong, I'm curious that in your opinion, is this depleted oil and gas reservoir, is that a strong location for a site, a Class 6 injection well?
It depends, based on my knowledge, doesn't matter if you have a depleted oil and gas production zone or deeper saline aquifer, whatever you have, you must have a detailed site characterization to prove this formation is good enough for the CO2 storage. So I don't have a strong opinion on whether those one can be a better candidate or best candidate than others, but it could be a candidate. Yeah. Sure. Depends on your categorization. Yeah.
Thank you. Yeah, that makes sense. And also, you note in your summary of your direct testimony that comprehensive site characterization can reduce uncertainty. I'm curious, in terms of Class 6 permanent CO2 injection in historic depleted oil or gas fields, or geologically connected locations, do those pose unique considerations for site characterization?
My answer will be yes. You also need a detailed site characterization, yes. To reduce the uncertainty, because you already produced the oil and gas for years and the reservoir property already changed during the production period, and your initial reservoir conditions parameters already altered for this production period. So technically, I will suggest to perform the detailed site characterization again on this depleted oil and gas reservoir. That's my answer.
Thank you.
Thank you.
And as part of that site characterization, are there additional considerations or concerns that come into play with a depleted oil or gas field?
You mean for the regulation portion or for the logging or testing or?
Of course, I think I'm thinking more in terms of site characterization.
I can speak for the logging, coring, and the sampling, those portion. Doesn't matter if you have a depleted oil and gas reservoir. You have to follow the order, follow the rules from EPA, from the NDAC, the proposed rules, if you got approved this time and follow these rules and do this kind of categorization on the logging, coring, and testing.
Okay.
Doesn't matter if you have previous data already, things always change during the production, right? That's my technical point of view.
Thank you. Appreciate it.
Yeah.
And in terms of considerations involved in a depleted oil or gas field, do those considerations when citing a Class 6 well in a depleted field, did they include an increased chance of leakage or risk of leakage of injected CO2?
That is out of my knowledge. I'm going to defer this one to probably my team member, Matt, who is working on the testing and monitoring plan for this proposal.
Okay. And Dr. Khaniani, is that something that you would have the expertise to speak to in terms of an injection zone or reservoir and how perforations may affect that?
As I said earlier, all the evaluation for any site need to be evaluated based on geomechanic reservoir and the possibility we have to do modeling, use enough data to make the conclusion. So based on your question, if the depleted reservoir affect the injection zone, we have to evaluate based on the modeling step that we have. So my answer will be, we need to study any case by case. So we cannot give a general answer.
Excuse me, could I add a little bit on?
Sure.
If for the depleted oil and gas production area, this formation in this area, if there any leakage or potential risk existing, so under the categorization, there is a corrective action plan included for that portion. So for more details, I would defer to Matt or to my team members for the next technical session. Yeah. Thank you.
Okay. Thank you for your answer. And I guess Dr. Khaniani, I'll just continue briefly with you. In terms of the site characterization, and you mentioned the need to study a zone regardless of the characterization, what that might show. In your opinion, would an injection zone that was a historic oil or gas field pose additional risks of leakage?
As I said, we need to study each case by case. It can and it cannot. So I cannot say any specific. We need to study that for any reservoir.
And is it true that any perforation into a CO2 injection zone poses additional risk potentially of effective containment of stored CO2?
Again, it needs modeling to evaluate. So perforation, you can inject the material inside. It can affect the skin. It can affect the environment. Maybe it improve, or maybe it has a different outcome. So we need to study for any well if the perforation has adverse effect.
And so my understanding you correctly that if there were a historic oil or gas field that had many different wells that were perforating an injection zone, that would require additional study for each of those wells.
Do you want to answer?
I will see, yes.
Okay, thank you. And then in that case, with the additional study required for those wells perforating that injection zone, would each of those wells be a potential leakage pathway that need to be studied?
That is all the evaluation and action items under the corrective action plan for the site characterization. So if you need more information, probably Greg from the next technical session could provide more information on those. Yeah.
Okay, and just briefly, what you're saying is that, if I understand correctly, each one of those wells that perforates the injection zone, because it perforates the injection zone, would require a study of whether that poses a risk, and you're offering that we would then need to do site characterization and potential corrective action for each of those wells. Is that correct?
That's correct.
And would this sort of a challenge, or would this need for study of corrective action also be the case in an active oil or gas reservoir field?
That's really out of my scope. Sorry about that.
Okay. And maybe the last question I'll have for either of you. In your opinion, based on site characterization, modeling, logging, would an active oil or gas field or reservoir serve as an effective injection zone for long-term sequestration of carbon dioxide?
So my understanding, you are trying to, if you're gonna do that operation, so you're gonna convert to the class 2 well, CO2 UR well, not the CCUS. That's my understanding. So that's a confusion for me on those two type of wells if you're gonna do that one in the active oil and gas reservoir. Okay, that's my understanding from your question.
Madam Hearing Officer. So again, a soft objection. I think that Mr. Pavlik is not, I don't believe that Mr. Pavlik is trying to elicit a legal response, but this is a question that has both a technical and a legal answer. So we're veering into territory where there is a technical criteria or answer where whether an active production zone could serve as a confining layer or a confining zone. However, it implies a legal analysis on whether or not that would be permissible. So I just want to caution there because it's come up twice, and I think to the extent that it's calling for a technical answer, the witness should answer.
All right, thank you, Mr. Tremaine, for putting in that on the record. I'm certain, Mr. Pavlik, you understand that these are not lawyers you're questioning, so we'll just leave that as a place marker there. Do you have other questions of Dr. Khaniani or Dr. Wong?
Yes, yeah, thank you, appreciate that. Yeah, I do briefly want to ask a similar, or I guess a summary of what you just said, Dr. Wong. So only speaking, please, to the technical aspects of a class 6 injection well. Are you saying that in terms of its technical components, a class 6 injection well would not be appropriately located in an active oil or gas field? That would instead be a class 2 injection well?
Technically, so I'm not sure how I'm gonna answer this question from the technical aspect, So basically, if you're gonna inject CO2 to a oil production zone, that's automatically goes to the enhanced oil recovery. there's definitely have some storage components there, but how are you going to define your permit to a Class 6?
I see. So if I'm understanding correctly, I guess maybe a question to clarify. Are you suggesting that this would be a Class 2 instead of a Class 6 well because though it has some storage aspects, it is not the permanent storage of that carbon dioxide? It's used for enhanced oil recovery. Is that correct?
Objection to form and outside the scope of Dr. Wong's testimony. If Dr. Wong's not testifying about Class 2 and this hearing is not about Class 2, so we're getting into production zones. Dr. Wong's testimony relates to logging, testing, et cetera.
I understand the temptation, Mr. Pavlik, but I have to ask you to stay within the scope of the Class 6 testimony we've heard today.
Okay, thank you. So Dr. Wong, I guess let's stick away from Class 2. I know that you had brought that up in answer to my question, but just Class 6 wells, focusing on those, technically speaking, is an active oil or gas reservoir an appropriate location for a Class 6 injection well?
This is out of my scope. Sorry, I don't know I don't have a firm answer for you.
Dr. Khaniani, would this be something that, as you're looking at injection zones and characteristics, in your opinion, would a Class 6 well be appropriately situated within an active, no longer depleted, but an active oil and gas production zone?
I will repeat the answer that I gave. So every situation, we have to perform modeling for the injection and production and inclusion of the other wells. So we need to perform simulation and modeling and make decision based on the modeling and engineering model that we have. We cannot make a general comment on this question.
And so, excuse me, if I'm understanding you correctly, in your opinion, it may be appropriate to locate a Class 6 injection well in an actively producing oil or gas field. Is that correct?
For analysis, yes. Maybe.
Thank you both. That's all I have. I appreciate it.
All right, thank you, Mr. Pavlik. Ms. Ruskavage-Barr?
Madam Hearing Officer, Wild Earth Guardians has no questions for these witnesses.
All right, thank you. Mr. Tremaine, do you have any redirect?
Yes, I believe I have one or two questions. Dr. Khaniani, were you responsible for drafting the confidentiality provision in the rule?
Drafting? No.
Okay. And I think we clarified that you are not an attorney, correct?
Yes.
Okay. In terms of implementation of the specific, you received questions about confidentiality. Is it fair to say that questions about how the confidentiality provisions work would be better addressed to in certain respects the next panel or legal argument?
Yes.
Thank you. One moment. No further redirect.
All right, thank you, Mr. Tremaine. We turn now to the commissioners. Commissioner Mpoma, would you like to begin the questioning?
I'll probably ask Ms. Koski to see if she wants to go first. I'll go first on the second panel.
Yeah, I can go first. That's fine. Thank you both for your time this morning. I will start with questions for Dr. Wang, or if it's for Dr. Khaniani, please feel free to jump in. One of the questions I have is that logging, sampling, and testing is defined to say that you only need to do that for relevant geologic formations. And I'm wondering, what are those relevant geologic formations?
So under the proposed rules, there are several components for the logging portion. Specifically for the surface casing portion, we need to identify the USW and perform the gamma ray resistivity, SP log, and Kepler logs before the casing installed. Okay. The casing portion, the surface portion, the main function is to protect the lowermost USDW. So this kind of logs can help us to identify those kind of information and provide a baseline data set for the future evaluation after the injection. Okay. And then for the before and upon the installation of the long-string casings, we also need the open hole well logs and cased hole well logs to evaluate the confining zone and the injection zones. Okay, those kind of logging and coring and testing gonna provide the baseline data set for this CCUS project developed by the operator, and then compare this data set for the future injection. Okay. I will not list all those kind of logging suite, the names, to save some time right here. Thank you.
So do you think it would be useful to do a full suite of logs for the entire well section and not just the injection and the confining zones to get a better understanding of all the different possible mineral resources or hazards through that whole area?
You mean from the surface to the bottom hole, the whole depth of the well bore, do all those kind of full field of the logging program?
Yeah, just to log the entire from the surface down to the injection zone.
To me, the most important, technically the most important portion is the water aquifers and the confining zones and the injection zones. Other formations will be the additional information for the well bore. It's not under the strict requirement from this rule, but technically I would recommend those rules, those log suite. Yes, if allowed, yes.
And what about, let's say, like formation fluid testing? Is that only required in the reservoir, or would that be required in maybe areas to understand if there's high H2S, which could cause more corrosion, or to understand the salinity in different water intervals as you're drilling through?
At least the confining zones and injection zones, and also from the water aquifers, at least.
Okay, thank you. Let's see. This might be a question for both of you. I know for the initial permit, you have to look at the geomechanical properties. And I was wondering if during the logging time before the injection is permitted, would you want to get, would the OCD want to ask for having in situ stress, magnitude, and orientation directions?
So your question is if OCD will ask the in situ stress orientation?
Yeah, right now I don't think it's set out in the rule for asking for that information. I was just wondering if that would be a useful thing to have in the rule.
I think it will be a good idea.
Okay, thank you.
Because those currently what we have right now is for New Mexico and even Texas, there are lots of publications that they discuss about the in situ stress, the direction, and also density. We can take advantage of that, and I think it's a good idea.
Yeah, those are a good starting point for sure. And then actually get in situ while they're drilling the well to understand exactly what's happening at the well bore. Let's see.
So I remember, if I remember correct, we have the MWD, the measurement while drilling. We have some measurement from the drill bit on the stress or some pressure monitoring. Will that be useful for the in situ stress analysis, something like that? Yeah, that's my suggestion on those. Yeah.
Okay. Yeah, thank you. And let's see. So a little bit about the well construction. It seems like the minimum for the rule is only 2 strings of casing, one more at the surface, and then one for the rest of the well bore. Do you think that is sufficient, or do you think there should be a higher standard to begin with?
I think we should.
For more detail, I would defer this question to Matt, but from my technical point of view, surface casing is for protect the USDW, and then intermediate casing is for the well bore, the stand up right there, and then the production casing is for protect provide the isolation, right? So it depends on the well depths and casing materials and cement strengths, So that's all the engineering design aspects. From here, in this NDAC rules we proposed right here, at least we follow the minimum requirement and add on the specific set characterization data set into that one to have a stress analysis on the well casing design and well bore diagram, and make sure there's no leakage, no burst, or all these kind of technical issues gonna happen. It should be fine. Yeah, that's my technical point of view.
Okay, thank you. So yesterday in your talk, I believe you were talking about monitoring for corrosion while the injection is occurring, like corrosion in the cement or in the well bore. I was wondering, is there a way for the operator to monitor for corrosion after the injection period?
So again, I will defer this question to Matt on the testing and monitoring plan, but I do believe we have a mature technology to perform this kind of monitoring for the cement. Yes, at least we have CBL, VDL at the very beginning, and then the casing inspection and then the pressure test. I don't know if there's any other additional requirement from the testing and monitoring plan, but I believe so. Yeah, it should be there.
Okay, thanks. And I don't know, maybe you're not the right person for this either, but I know for the well design, there has to be information provided about the safety of the cement and all the tubular and everything. Do you think that there should be laboratory testing of the cement with exactly the chemistry of what the CO2 is going to be injected to better understand the corrosion possibilities?
So the Science Society and Engineering Society already did a lot of research on the CO2 resistant cement, and also the commercial provider of the CO2 resistant cement, they already did those kind of preliminary lab tests, which is required from my previous Class 6 permit application process. So I would recommend lab test is recommended for this process, yes.
So do you think it should be recommended in this rule to include that?
To
testing?
this rule, that's automatic scope. I don't.
Okay.
Yeah, I'm sure, but technically, we should have all those kind of lab test data from the service company. Yeah, as a proof for the as a additional document for the Class 6 permit. Yeah.
Okay, thank you. Okay, I think my next questions are probably more for Dr. Khaniani.
Thank you.
I want to talk a little bit about the 3D seismic. And I was wondering, if you don't have 3D seismic for an area, do you think you could reliably characterize any faults or fractures in the system?
So let's say we don't have the 3D seismic, then we will rely on geology, the available data, for example, the well logging that we have. There are different teams, geologists, reservoir engineers. We evaluate fault still, we can evaluate. And based on the historical fault and the in situ stress regime, we can identify fault based on the well logs and geological top. And based on that, we still can characterize and model the fault based on the information that we have. But it will not be as more certain that if we combine it with the seismic data.
Mm-hmm. Yeah, that's one of my concerns is that 3D seismic isn't a requirement in here because I think it is very difficult to reliably characterize the reservoir without those tools. And I guess kind of on the same note, if you use 2D seismic data, that's still pretty challenging to understand like the orientation and direction of faults, correct?
Correct.
And 3D seismic could definitely help with that.
That improve the certainty of analysis.
Okay, thank you. Let's see. So in your rebuttal, you addressed the 90% injection pressure.
Mm-hmm.
I was just wondering where that 90% came from, like what's the background on that, and if you know if other states are also following the 90% guidelines in their Class 6.
That 90% come from APA. They use it for Class 6 and even Class 2 follows that. And so it's a safety margin because in the terms of simulation, when we do model like a fault activation, if you want to model if there will be a secondary fracture, then the fracture pressure plays a role, and you have to do the modeling. And the EPA plays 10% margin, safety margin because of the uncertainty we have. The reason for rebuttal was not that we don't want to have like a higher, like 80% safety margin. The reason was that because of the experience that, for example, a well we had before, we cannot make it like a mandate for 80% safety margin. We have to do the modeling, and then we want to stick with the current EPA that already has been worked, because each reservoir has a different condition, and we don't want to mandate 80% safety margin. We want to put it in the hand of the director to make the decision. There will be possibility that based on the data set and a lot of fracture and other history in the area, we may make decision even make it 60%. Okay, so we don't want to put it as a mandate in a statewide, like a universal number. That's what my point was.
Is there a advantage to be injecting at 90% rather than 80%?
It's about optimization of the injection. You want to have maximum injection value in the region, and you want to have the pressure limit that it is safe to go. So there will be definitely advantage that it's amount of the fluid you send to subsurface.
And do you happen to know if any other states' Class 6 programs, are they all doing 90% as well?
I will refer this to maybe Greg or Matt.
Okay, thank you. And one other question, so as you're injecting, the reservoir will become more pressurized, correct?
Yes.
So how often will the OCD look at that increase in pressure to change the amount that can, like the amount that can be injected? Does that make sense? Sorry.
I would like to refer that to Matt as well.
Okay. And if you're injecting into zones that might already be pressurized, would that affect how much you would want to, how high you'd want to inject?
Yeah, that fits on the category of geomechanics. I think we make the calculation. We want to estimate how much pressure we can have in order to make like activation of fault or create a fracture. We do fault slip potential analysis, and that answers the question how much pressure we can have, how much induced pressure we can put in the reservoir. We make the calculation.
And if you're going to be injecting in an area that might already have a high seismic background, would that be something that would want to be looked at as part of the review?
We have different protocols. Even New Mexico microseismic monitoring, they have different monitoring mandate, and we will follow on that. Regardless if we have high seismic activity in a region, we need to understand what is the source of the activity, and we need to also make sure that that is a result of our injection. And after we observe the monitoring, then we go for a corrective action, and we want to make sure that it doesn't create fault. We want to make sure that it's not creating a secondary fault that goes to USW.
Thank you. Yeah, that seems like a very important part of this approval process. Let's see. When you're mapping faults using 3D seismic or whatever tool you end up using, I think the rule only calls for looking at faults that cross-cut the injection zone and the confining zone. Wouldn't you want to have an understanding of all the faults in the area?
So we have area of review because we do estimation of how much our fault will be. So if we want to go for other fault in the region, if it's non-relevant, we don't study that.
What if it's a fault within the area of review that might be deeper than the injection zone or the confining zone? You'd still want to look at that, correct?
Again, it depends if we have USDW or other zone that we don't want the fluid to migrate, or if it doesn't affect, then if it's deeper, we will not take care of that.
And I mean, the goal though is to not have fluid escape the injection zone at all, regardless of USDWs, correct?
Yes.
So I think it might be important to look at faults in the whole
Yeah, we
area.
need to make the simulation and make sure that if it reaches and where it goes and how it affects it.
Okay. And I guess one other kind of modeling question for you. So you said that the pressure zone in the area of review has some uncertainty with it. Do you think, is that uncertainty included in the area of review, or do you think there should be an extra buffer zone around to account for that uncertainty?
No, it definitely is included in the area of review process.
And how much do you think that, maybe you can't answer this, but how much uncertainty is usually tacked on? Do you know?
I have not in my site for now, but they have different like a correct calibration, history matching, and they want to make sure that because this like a class 6, you get new data during the time, and you want to put that in your evaluation, and it's a standard for reservoir engineering to evaluate that. But if you need a specific number of uncertainty, maybe Dr. Wang or Matt can answer that.
Okay. Do you think adding an extra buffer on there would be a good idea? Just to add some extra room, wiggle room, if things move faster or differently than you expect?
I believe we have to stick on the modeling and the data. And I think we cannot put universal extra margin. We need to stick with the simulation that we have, modeling, and make sure that everything is safe within the standard. But sometimes maybe the uncertainty of our data is very high, then we should refer to the director and ask for other margin.
Okay, thank you. I don't have any other questions.
All right, thank you. Commissioner Mpoma?
Can we take about 5 minutes break?
Oh, yes. Yes, absolutely. Thank you. Let's take 10 minutes and come back at 10:20. Let's come back from the break, please. Commissioner Ampoma, do you have questions of Dr. Wong or Dr. Khaniani?
Yes, I do. Thank you, Dr. Wang and Dr. Khaniani, for coming in to testify on this important rulemaking. Now, I just want to clarify that all questions with regards to the rule, you prefer I defer that to the second panel, or I can ask you questions about the rule itself?
Yes.
Which one is it?
We prefer to defer that one to the rules group, yeah.
Okay. And also, so then your role is more or less doing technical work to support the rule.
That's correct.
Okay.
Yes.
Okay, good. And also, Dr. Khaniani, so you are testifying specifically on faults, fractures, induced seismicity geomechanics, fault pressure limits, reservoir simulation, uncertainty, pressure front behavior. Is that correct?
Correct.
Okay. So, Dr. Wang, you are, I just want to make sure I know who I'm asking my questions to. So, Dr. Wang, you are talking about well logs, formation testing, MIT, plugin materials, plugin verification, and well closure.
All the items under the logging, sampling, and testing prior to the injection valve operation and injection valve plugging.
And also, you will feel comfortable probably that I don't go into the class 2 with you. Is that fair?
That's kind of out of my scope, yes.
Okay. So let me start with Dr. Khaniani. You know, we've discussed a lot about the model uncertainties. Now, let me ask you, must model include sensitivity and uncertainty analysis? And if so, what parameters must be varied?
So there are many parameters. Some of the parameters are related to the model itself. The parameter related to the production, like diffusivity, related to the diffusivity, and also the production. So I don't know if I answered your question.
I'm listening. Okay. So based on all the discussions and even the cross, you believe that there are a lot of uncertainties that at least the operator has to consider. Is that fair?
There are some uncertainty for our measurement. For example, when logging, if you want to estimate porosity and permeability, you have some uncertainty in terms of measurement and also in terms of interpolation into the reservoir. So that's it. Yeah, there are some uncertainty for the measurement, and it's not about this. I mean, you have this uncertainty in other field of engineering as well, not only in reservoir.
So if you look at a normal Class 6 application, would you agree with me that there is a component that an operator has to perform uncertainty analysis, especially to the model?
Yes.
Okay. Now, would you also agree with me that since there are numerous number of uncertainties that could be more or less studied under a particular or site-specific situation, there should be a way where there has to be a prior discussion with the director to more or less decide what type of uncertainties that needs to be modeled as part of the AOL application. Would you agree with that?
Yes.
Okay. And if that is not in the rule, do you believe that we should consider incorporating that into the rule?
Regarding the problem, regarding the rules, I defer to the lawyers or other, maybe Matt and Greg, they can answer this question about the ruling.
But at least you agree with me that it is an important component that at least the second panel needs to address.
Yeah, I agree that it is very important to discuss the uncertainty.
Now, still on that, must an applicant quantify probabilistic ranges for plume and pressure front extent, or is a single deterministic type of modeling?
Can you repeat that again?
Okay. So I'm asking you, must the applicant quantify the probabilistic ranges of plume? That'll be the CO2 plume, right? And then also the pressure front extent, or you just, or let's say, or you subscribe to the fact that it just has to be a single deterministic type of modeling.
No, I agree with you. This should be probabilistic, and I think that is part of the like a standard method that.
You believe that is a standard
People
method?
do sensitivity analysis in the reservoir, and they do plus minus of the parameter, and at the end they provide. Actually, the outcome of the simulation is probabilistic at the end.
Have you reviewed, and so I can jump in and help here if you would, have you reviewed a typical UIC Class 6 permit before that you've seen that operators are more or less doing probabilistic assessment for CO2 plume and then for pressure front?
I have participated in different MRV plans, and based on that, I saw some reports, but it was related to Class 2 MRV problem.
The second panel definitely will help here. Thank you. Now, so we've been discussing about the models, and you talked about the uncertainties. We're doing the history matching. We're trying to make our model more realistic. But how is OCD going to determine if this model is overfitting, or let's say if it's overfitted model, from your point of view?
In my view, we need to make sure that we followed all of the procedure in terms of gaining the data, perform modeling, how accurate is the modeling, and also we do validation of the model based on the available data that we have. But that will be initial step, but after production, we have more data than we include into the reservoir to improve the model. But so basically, we do the simulation of the model. We want to make sure that the procedure is accurate.
So based on your response, clearly you are saying that prior to, let's say during the permit to inject, no, permit to construct, there's not a lot of information. So definitely the model might not necessarily 100% be reliable. But once we have enough data, we have to calibrate. And that calibration more or less reduces the uncertainty. Are we on the same page?
So I agree about the uncertainty, but I don't know if the model is unreliable because we are using the physics behind the diffusion equation, and also we are combining that with other available data based on the physics. But I don't say the terminology of unreliable. I do not agree, but about uncertainty, I agree with you. There are uncertainty about the model creation. And the way that we sense the underground model with the 3D seismic, the quality of the seismic, there are uncertainty involved. So.
Yeah, so I was getting at, if I use unreliable, strike that. Okay, but where I was getting at is that the initial models do have a higher uncertainty. And you said that once we start injecting, we are having pressure data, injection data, so we can calibrate this model to even reduce the uncertainty.
Correct.
Okay. Now, on that one, what objective measure from your experience of model to fit field mismatch will trigger recalibration or AOR reevaluation?
I would like to refer this to Sai. Maybe you want to elaborate more on this.
Could you please repeat your question?
So we just discussed about the different type of models where initial models, higher uncertainty. As we are getting more data, less uncertainty. So I'm asking you, OCD do have the initial model and then a subsequent model. So I'm asking, what should be the measure, okay, the objective measure, okay, objective measure of model to fit mismatch that will trigger a recalibration or let's say reevaluation of the OR?
I don't think I can cover this question for you regarding to the modeling parameters.
Okay, I'll put this panel here. Okay. Now, so the question probably still for Dr. Khaniani. Talking still about the uncertainty analysis here. Do you believe that an operator should establish their own project-specific mismatch, or they can just put in the application and wait for the director to step in?
You mean if any operator, they should have their own standard instead of the director supervision?
So assuming, let's say, an operator will say that in our business, normally when you do history matching, you want to be less than 10%, right? So this is a standard rule of thumb, okay? And that is a standard. So at the time where, let's say, an operator is submitting the reevaluation of the AOR based on the history matching and all of that, do you believe that the operator should establish the mismatch conditions, or they don't need to, they just have to wait for the director to give those conditions?
I think this is, I can refer this to the other panel. It is about the ruling.
Yeah, but I thought you are testifying on simulation modeling.
Yeah, but I mean, you say if the operator should make their analysis or they should wait for operator to tell them what analysis they should do. And this is regarding to the ruling.
So I'm curious though, based on the cross, you said that, or even based on your testimony, you're talking about the fact that all information on the modeling will be made available to the general public, so that the public can evaluate and then see what is there.
So my discussion was not, about the public comments or available information. My comment is that if we are going to include the third-party evaluation, we have uncertainty regarding the third party itself. And there can be dispute about the standard that a third party can make, about regulations, about the standard that they have, and the assumption that any third party can have, and also there will be discussion about the third party's certification. So a lot of things that any third party can have different criteria with the other third party. So my ruling was that we should not mandate employing a third party verification in order to do the permit. Instead, we should rely, because the permit process require discussion with OCD, or even they will review it. And then there are a lot of public information that will be transparently will be available to the public. So any third party, if they are interested, they can use this information to perform the evaluation. Of course, they cannot do all of the evaluation that an operator is doing, but they can, if they are interested, they can study any permit process. But so my ruling was that we cannot just have like a standard universal requirement and mandate that a third party is required to evaluate that, because OCD, they will already review this process.
Now that you brought that up, let's pick that one up. Now, you're saying that OCD and EPA already conduct technical review, permit technical review. Now, let me ask you, are you familiar with how EPA reviews its Class 6 permit?
Regarding the New Mexico here,
No, general. How EPA, let's say EPA Region 6, are you familiar with how they review Class 6 permits?
no, I am not.
So then why do you say that, let me strike that. So you went on to say public notice and comment already allow outside technical review. So when you backtrack on your response that you are not saying that the data is going to be available to the public to make their own determination, how do you square that with that statement though?
So, so we are have been in process of the, OCD permit process, and in that one, we put a lot of information in the report that will be available for the public. So that was the comment I made for the information that we give and then presented. It will be in the public domain.
Now, since you said you are not familiar with how EPA does its permit, that will be the next panel, or probably Sai can chime in if he has any input on that. EPA does use technical experts, which are third parties. Even EPA has used national labs to perform reviews. So we are saying that you are saying that the rules that you are putting across here is even stricter than that of EPA. So I want to understand how you feel like a third-party review should not necessarily be mandated.
So third party, as you mentioned, may be mandated by the EPA, right? But I cannot comment on that.
Commissioner Ampomah, can I add a little more on the review process? So there's a confusion for me for the third party. You mentioned that EPA assigned the review task to national labs, the third party. That's the case because EPA Region 6 didn't have enough employees to review this process. They had to assign or release those kind of review process or components to the third party. So I get confusion from here. Is that necessary to put a third party right here for review if OCD have enough personnel or EPA have enough personnel to review? Yeah, that's my confusion portion, yeah.
Okay. Mm-hmm. So from your experience, do you believe that, and this one, I was waiting for the next panel, but since you brought it up, do you believe that, let's say, UIC classes group and Mr. Winkler talked about it, that they have 3 staffs, permanent staffs. Do you believe that that is enough to review a UIC Class 6 permit? That question was not for you, but you brought it up, so.
I don't know.
Okay.
This, yeah.
Now, since you brought this up, now, don't you believe that OCD more or less also have to use the state resources that is available? Now you do have, and you don't necessarily have to respond to this, the next panel, but since you brought it up, I just want to complete the transcript. You do have the Bureau of Geology in the state. You do have Petroleum Recovery Research Center in the state. All do have tremendous experience in this area. So don't you believe that the state should rely on the expertise in the reviews of these applications?
I will defer this question to the next panel.
Okay, so just to complete my, just to complete the statement. Okay. Dr. Khaniani, let's come back to you. With regards to the the seismic issues that we're discussing, I mean, it sounds to me that you are pro-seismic. You really want to see seismic. You really want to see seismic happening. But you don't want it to be mandated. Is that your position?
I cannot comment on that.
But I mean, you are presenting to us about all the importance of site characterization.
I will say my personal view.
Yes.
And my personal view is that seismic is very important, not only about finding fault, but also finding the structure of subsurface in order to reduce the uncertainty that we just mentioned about porosity, permeability. We can extend that based on the properties that we have. So in my view, permit any analysis of the drilling, we need to have like information from the subsurface. There are not only the 3D seismic, and there are other type of seismic data that they can have. For example, VSB, they are like a cross seismic. So anything that helps to identify the subsurface structure, the properties, and the fault system, I think I advocate that.
And even on top of that, tell the commission how an operator is going to be able to establish a plume front in 3D without a baseline seismic data and a 4D seismic data. You're going to your attorney?
I think I will refer to my attorney.
Refer to the attorney?
Commissioner, I think you said 40. I didn't understand the question.
He does.
4D means you repeat the seismic during the time, and you want to see the plume migration during the time. So
let me rephrase my question, because we are still on the importance of the 3D seismic data, right? So we're talking about models, uncertainties.
Yes.
As a geophysicist,
yes,
the 3D seismic can also help you to really see the plume. Is that correct?
I agree, definitely.
So if we want to see an actual physical evidence of the plume, why should 3D seismic not be mandated?
I'm not sure about the mandating 3D seismic, because I think maybe the other panels can respond to that. But I think it will be very helpful tool to identify the plume and to see how they extend if they reach the fault. So it gives us a lot of information, but mandating a 3D seismic, first of all, maybe there are other factors that we can use. For example, if you have a fault, you can do other well testing to see the fault hitting the system or not. I mean, you can see the boundary. There are other evaluation, but for me, I cannot comment on mandating the 3D seismic. I refer this to my lawyer, and I don't know about rules.
Commissioner Point, if I may, I think the distinction here is that Dr. Khaniani is trying to describe the technical basis and how the modeling would work in response to your questions, but he's certainly, and I think appropriately, apprehensive of providing like the policy decision or recommendation of the OCD, right? So I think we will have witnesses that can talk about this, and it's something that if there's a proposal to include 3D seismic as a requirement in, because as I say here today, I don't recall that being a comment or proposed edit that was rejected. I may have that wrong. But that's something that we can consider and always take a position on in closing. So that's the distinction here. I just want to represent we want to answer your questions, but I think the decision of whether to include something in the rule was not something that we asked either of these witnesses to testify to.
Thank you. And I'm building my questions for the next panel, actually. So, because I want to hear what the technical expert is saying, and then I want to hear how the team members that really worked on the rule is also saying, based on what the technical witness is saying. Dr. Khaniani, let me, still on the seismic. Now, the two major basins in the state of New Mexico, you have San Juan Basin. You do have the Permian Basin. You've done a lot of work, probably in these two basins. Do you believe that an operator has to do all they can to see if 3D seismic data exists and use it as part of the application?
My answer is yes.
Okay. And you see, so if we are to discuss more about why 3D seismic more or less cannot necessarily be mandated, it's about, let's say, if you are going to shoot 3D seismic with multiple landowners, you have Navajo Nation, you have State Lands Office, you have private, those could be very challenging, right? So,
correct.
And also, even if you look at our two bases, I mean, a lot of work has been done there, right? So, but I just wanted to probe that and still more or less put on record how important the 3D seismic is.
Yes, as Dr. Ramboma mentioned, I want to confirm that New Mexico has a challenging geology, most of the region, based on my experience from the north of New Mexico to the south. All of them, we had challenging geology, a lot of fault exists, usually fault exists, and but we cannot just generalize that based on the experience that I had. We had fault. Yes, I agree. We have to emphasize on the presence of seismic data, and it is very important from the perspective of modeling and also the faults. So, but I cannot generalize that for any region. But I had some experience, and we saw that there were faults and even uplifting different region. We experienced that, and also there was lots of faults. I confirm, I agree with you in the technical aspect. The seismic plays very important role.
So, Dr. Khaniani, you discussed about presence of faults. Now, can you tell the commission how applicants are going to be able to describe the fault as either being sealing or, let's say, closed?
Yeah, so when we have faults, it can be sealing, it can be transmissive. So it depends on each fault. So we cannot automatically exclude a fault as like a transmissive, or we cannot make a conclusion, a type of fault. But what we can do is rely on different like analysis and different assumption to reduce the risk. So the fault is transmissive if it can carry the fluid from the injection zone to the other unwanted zone. And it can be also sealing because of the property that we have on the fault. For example, it depends on the stress of the region or how the separating layers lay on each other, okay? So it depends on the geological formation, the stress regime, and your injection. So it's a very careful consideration that I would say about the caring about the fault system.
And even it can still be uncertain whether an operator can say that, okay, these faults are open, but it could probably end up that it's closed.
Correct.
So do you believe that if there is any suspected presence of faults in an area, then operator has to include that as part of their uncertainty analysis in the application?
Correct. They should perform uncertainty on the fault and do different evaluation based on different scenario. And they should assume that this is sealing, or they should assume that this is open. And then if that is open, where are the contaminated fluid will go? And if it's closed, how much pressure increase or other factor affect the simulation? I agree.
Now, in the OR, or let's say even in the UIC Class 6 application, usually operators are required to do the regional seismicity analysis, right? So my question to you is that how far beyond a modeled AOR should regional seismicity and fault systems be evaluated?
Oh, okay. So for the seismicity, we have the mandate from the New Mexico macroseismicity data. I don't have that number for now, but I can refer you later. But it is about magnitude of the macroseismicity, and if that happens during the production, you have to consider certain miles. I think it will be 3, 6 miles or 10 miles. I cannot remember right now, but I can give you later. But it's about occurrence. For example, if you have like 2.5 within a month, then you have to perform reporting. So that is already mandated. Okay. And there are some scenario that you have bigger than magnitude 3 during the production, then you have to restrict drilling in some certain area. So that already have been documented. And it also depends on the macroseismicity or that we receive, where the source is and what is the nature of that. So we have to evaluate that one as well.
So are you referring to the specific traffic light protocols?
No, New Mexico macroseismicity protocols.
More or less probably the same. Okay. So then let me ask that, do you believe that operators, more or less as part of the application, has to more or less establish that in consultation, let's say, with what you just described as the state microseismic protocols?
Yes.
Okay. But not necessarily mandated for every project, right?
I am not sure about that.
Yeah, because if we do know the state, we do know our basins. We do know basins where microseismicity is a big deal, right? Let's say if you're talking about the Permian compared to, let's say, the San Juan. So areas where there is no microseismic prone area, then you're not necessarily mandating people to be really focusing on these.
Correct.
Okay. Now let me ask, so what baseline period is necessary, okay, to distinguish natural seismicity from induced seismicity events?
That requires analysis. I cannot answer that out of now.
And then you said that there are already threshold
Yes.
already established in the state.
Yes.
So when operator is operating and more or less there is a microseismic event, it triggers, then there's protocols as to what they will follow.
Correct. And microseismicity that we are reported during the well, we have location or orientation. There are different factors like a frequency, but the natural occurring usually have lower frequency. That's what I can comment on that.
Now, and if you are not comfortable responding to this, you can defer, but based on your experience in this field, let's say there is a microseismic event that happened, okay? What are the criteria for restarting injection after, let's say, a microseismic event, based on your experience, yeah?
I would say, let's say a macroseismic event happens and we recorded and we are suspected that there is a fracture and we created a fracture to the confinement zone or other sealing zone, then we need to do the corrective action plan and make sure that this is related to the fracture. We have to do secondary analysis to evaluate what is the source of that macroseismic, and if the fracture happened, then we need to evaluate our data and make a simulation if that has happened for the new fracture.
So then is it your testimony that a revised geomechanical model will be required, once there is a microseismic event, prior to, let's say, the director giving the permission to continue the injection? Is that your testimony?
I didn't discuss about mandating a
not
new rule.
mandating, not mandating. We're just talking about when should injection resume, right? And as part of this rulemaking, we also have to make sure that we are establishing the safeguards for the public to have confidence in the rule that we are more or less working through now. So I'm asking you, you talked about if there is a microseismic event, there has to be investigation, and even to the point where stress models needs to be updated.
Yes.
So I'm asking you, should that be done as a condition for the director to give the go-ahead to restart injection?
I think so.
Now, let's talk about cumulative. Let's say company A, company B, they are all operating, and all of a sudden there is a microseismic event that happens. As a technical expert advising OCD, okay, in the UIC Class 6 program, what happens?
So you identify the location, and if that location related to and then also you are doing your geomechanical analysis, and if that is related to your operation, you have to take action, corrective action, and go with your, like as you mentioned, go with your secondary analysis, and if that is related to the fracture, or it was just a macroseismic event, and maybe it's not related to creation of the new fracture system. So we have to evaluate that and see if that is related to this well, class 6 well, or other. If I understand your question.
No, that's good. But I was more or less looking for or wanted to discuss about, let's say, company A, company B. Now, the analysis needs to be done in terms of you located right here is the location of the event. Now, there's another one operating here. I'm asking, should there be, let's say, any radius with regards to operations where a microseismic event happens, there has to be a boundary of investigation. That is where I'm getting to.
Yes, we are evaluating the AUR. I think if that is within your AUR zone, that creates a macroseismic zone, because you induce the fracture, or you induce the macroseismicity event due to the increase in the pressure. So I would suggest to look at the AUR region that you have already predicted.
So you discussed a numerous number of pressures. Now, and let me look at my notes here. You talked about the formation fracture pressure. You talk about fault reactivation threshold. You talk about confining zone integrity.
Yeah.
Now, based on the discussion with my co-commissioner, you said 90% of the fracture pressure is more or less what is in the regulation. But you've also discussed all these other pressures. So should the director consider all these other pressures before setting up, and not necessarily saying 90%, what the fracture pressure should be or operating pressure should be?
I agree. The operator should have, this conversation, and based on the data that you have, they make the decision if you want to use 90% or 80% or 70%, based on the region that you have. So, not operator, the director should have this authority. So based on the information that the operator, they give them.
So you're saying that it's not 100% automatic, that even though the rule is saying, or EPA is suggesting 90%, the director has to consider all the other three pressures before coming up with that number?
Correct.
Okay. And not necessarily 80%?
Correct.
Okay. Now, so if I go to slide number 17, that is a rebuttal where you're talking about, I think there was a question about the models being unreliable. And even you went back and forth with me on that. Yes. Now, you were saying that Class 6 models are built on site-specific data, and you list them. So let me ask you, are you mandating a strut well in locations where there is no data in the injection zone or or let's say the storage complex?
I cannot answer because if there is no data, then you have a lot of uncertainty, correct? So
Let me rephrase my question. So you saying that you are challenging the models are we cannot tell models as unreliable, right?
correct.
Because you are saying that class 6 models are built, and I'm reading from your slide 17, this will be a rebuttal. So you're saying that class 6 models are built from site-specific data. And I'm asking you, in instances where there has not been any penetration, or let's say there are penetrations, but this information that you've listed here is not available, are you suggesting that an operator has to have a strut well to have all this information before they can put up a UIC Class 6 application?
I would refer that to the other panel answer this.
If you don't feel comfortable responding to that, then I'm not sure the unreliable term that is being used to categorize some type of models, I don't think you can dispute that.
I dispute about unreliability of the reservoir simulation and those modeling. They are based on the physics. We have uncertainty on the input information, but they will, once we get like a more accurate, they are not unreliable. That's what I refer to. But
okay, I'll left you off the hook now. Let me go to Dr. Wang. Let me go to your presentation here. So, Dr. Wang, I'm looking at your presentation, and I'm looking at slide number 4, where you list all the logs that are mandated pre-drilling.
Yes,
yeah,
Commissioner.
yeah, that is the permit to construct. So, do you believe that these logs that based on the rule we are mandating, right? Do you believe that these logs can establish a reliable pre-injection baseline against, let's say, any issues that could happen in the future?
Yes, I do.
Now, are these logs, any of them, capable of detecting microannular flow or degradation behind multiple casing strengths?
To my understanding, could you please repeat your question again? Sorry, I need to be very clear.
Yeah, sure. I started my question asking about, do you believe that these logs that in the rule that we are mandating set a baseline for us? You said yes.
Yes.
So I'm asking you, because definitely with regards to, let's say, time lapse, we look at the baseline and then the time lapse to look at the differences and said, okay, there's something going on there. Let's go check it out, right? So I'm asking you, do you believe that these logs that we have are capable of detecting microannular flow, meaning outside the flow, in the annulus, okay? Or degradation behind multiple casing strengths?
For the multiple casing strengths, technically there is a little bit of challenge to detect these kind of macro channels for over 3 casing layers. But under this proposed rules, we have the surface casing set up, placed, and then do the CBL, VDL. And then for the production long-string casing, we also have the single layer for the CBL VDL. I think that should be able to provide a baseline data for comparison with the future injection, yes.
Now, let me ask you, with your experience in UIC Class 6 permit applications, and I don't know whether you've done some reviews here and there, does companies go beyond these logs or just restricted to these logs?
Based on my experience, some operators may go beyond, but at least they meet the minimum requirements and have the baseline data and have a good interpretation of the data set. It should be certified for this permit. Yeah.
So even though the rule is mandating these, but operators normally would have to evaluate their situation and then come up with a logging plan to help them in the long term.
Technically, yes.
Okay. Now, you talked about fall-off test. Is that correct? The pressure test?
Yes.
Okay. Now, how will the fall-off test be used to estimate the transmissibility, the skin boundaries, and then the pressure communications?
So the fall-off test, the procedure is generally you pump or inject the proved fluid in the at a constant rate, and then you shut in the valve. Then you record the bottom pressure, and then get the interpretation for the reservoir conditions. Yeah. So that's the procedure to get the data from the test, and then from the bottom pressure, you can analyze the reservoir pressure decline curves. And from there, you can analyze the skin factor and some other factors like you mentioned. Yeah.
Now, so based on the rule that you're proposing, or OCD is proposing, interference test is not a requirement, right?
When you mention interference test, could you please specify these terms?
Okay. So let's say, at what point should interference between two wells be a factor here for OCD to, or let's say for the director to recommend, or no, for the director to ask for interference test?
That one, I will defer this one to the next session, yeah.
Okay, okay. Now, must the test design for the pressure fall-off test, must the test design and interpretation be independently reviewed by OCD before the results are accepted?
Technically, yes, but for the rulemaking, I will defer that one to my next session, yeah.
But is your testimony that
yes,
at least another person has to look at it?
Yes.
Before it is accepted? Okay, good. Let me ask you these questions. I mean, probably Mr. Eales can respond to that as well, but so if you don't feel comfortable, you just pass it on.
Sure.
Now, what plugin standard applies to a legacy well exposed to, let's say, the potential carbonic acid, and let's say a sustained elevated pressure?
Is this portion related to the non-injection well or some other well types?
Yeah, so these ones are legacy abandoned wells.
So that one, I will defer that one to Matt Eales, who is working on the testing and monitoring plan. Yeah.
Okay. Then I'm going to leave all remaining ones for Matt, for Mr. Eales. Okay. Now, you talked about cement.
Uh-huh.
Now, how will cement compatibility with CO2-rich fluids be demonstrated for the expected duration of risk?
If I understand your question correct, you're asking how this cement can be compatible to the CO2 with fluid, right? So the service provider and all of those and other technical papers or lab tests already performed for this specific formula where we have those CO2 resistant components added to the cement. For example, the Class C cement tab, okay? So all those kind of cement already have a reaction test with the fluid from the service vendor. That information should be provided to the applicants, to the operator for further evaluation on this product. Yeah.
So there was a discussion either from my co-counsel or from other parties. So they were talking about the corrosion resistant cement.
Mm-hmm.
Now, help the commission to understand how a company chooses a cement or a casing strength.
So the service company developed this formula by their own techniques, and they applied this kind of cement already in the CO2 environment. Like, let's see, the CO2 UR well, and for example, in New Mexico, the Class 2 well for the acid gas injection well. So there is approved evidence to show this kind of cement are compatible to the CO2 enriched environment. Yeah, that is going to be a desired document. Technically, should be request from the service company. Yeah.
Now, is it typical that, let's say, a company A who wants to decide on the type of cement that they want to use, more or less give their site-specific information to the service company to verify, to recommend what type of casing strengths, or let's say what type of cement, based on their own analysis, could be useful. Is that correct?
Could you please repeat?
So I'm asking you, is it typical industry practice where operators will provide site-specific information like salinity, like, let's say, the composition of the brine, to a service company as part of their review in choosing the cement and then also even the casing strength?
Technically, yes.
Dr. Wang, so how do impurities and formation fluids affect the long-term performance of plugging cement and, let's say, any other well barriers?
So after the series of injection, there still have the CO2 fluid inside the well ball and near well ball. And those kind of fluid are gonna, when you do the plugging, this kind of fluid, CO2 enriched fluid, gonna react gradually or very slowly with your cement plugs. And this is kind of like a consideration factor when you place the cement plugs and other mechanical plugs. Let's see, the packers and bridge plugs, etc. Yeah.
So then that is why we need to know if your CO2 stream, your composition is changing, then we need to know that and see how compatible it is with your completion.
Technically, yes.
Dr. Wang and Dr. Khaniani, thanks so much for your time today. Appreciate your service. Thank you.
Thank you, Dr. Ampama.
Chair Chang, do you have questions of this panel?
I do not have any questions that haven't already been covered, so I appreciate your time. Thank you.
Thank you.
Thank you.
Is there any reason not to excuse this panel? Mr. Tremaine, anything further?
Nothing further.
All right. Thank you very much, gentlemen.
Thank you.
Will we bring up the other panel? Should we take a short break?
If we could take a short break and kind of rearrange, we do have, I'm open to the pleasure of the commission. We have 3 seats set up. I think we can add another table, 3 microphones, so we have 4. We're a little limited on space, but it seems to be working better over there than the alternatives.
Sounds good. Let's take 10 minutes. 11:25. We are back after a short break. Do we need 2 more folks on this panel, or are they online? 1 more. Oh, yes, okay.
We need one more, and he's in the room. Well, not in the room, apparently in another room. Let me find him.
A much smaller room, maybe. Okay. Sorry, we're going to stand down for 2 minutes. All righty, we are back after a short break. This is OCD's second panel. Mr. Wrinkle, Dr. Schnaar, Mr. Eales, and Ms. Raney. Mr. Tucker, do you have questions of this panel?
I do. Thank you very much.
Please go ahead.
Good morning, panel. Aaron Tucker on behalf of OCC USA. I'd like to start off by just thanking the division and all the members of the Rule Team staff for the work to put this proposal together. OCC supports New Mexico's efforts to obtain Class 6 primacy and generally supports the draft rules with some minor modifications. Towards that end, I have a few clarifying questions I'd like to ask today of the panel. Mr. Wrinkle, I'd like to start with you. On page 9 of your direct testimony, you testify regarding OCD's automatic permit termination provision. That proposed rule would provide that a permit automatically expires if drilling operations have not begun within that 2-year window, correct?
That is correct, yeah.
Do the federal rules include a similar automatic permit termination provision?
I believe they do, but it's 5 years. I'm looking at Gregory to see if he knows.
Off the top of my head, I don't know, but I don't believe that they do.
Okay.
All right, thank you. Could you please explain how the division selected 2 years for the automatic permit termination provision?
Yes, I believe, when we were all together, discussing, what we were like to go more stringent upon, we landed on 2 years because in the past, I believe that we've had, issues with operators not moving forward on projects. And we believe that 2 years was ample time, plus you get an extension as well.
When you're talking about past projects, you're not referring to Class 6 projects, right?
No, because we haven't had primacy over those yet.
What types of projects were
menagerie of them, mostly UIC though, more complicated Class 2s, AGIs, things of that nature.
Class 2 wells, okay. As you mentioned, the proposed rules also allow operators to request an extension, correct?
Yes.
What situations or circumstances did the division have in mind when it proposed to allow operators to request an extension of time?
Sure, and that can be numerous different things, right? Right of ways, plugging operations for wells, that are in the AOR, material sourcing, that kind of thing that they may be, 2 years out for certain, chrome products or things like that. So anything that is justifiable, right, that is out of the applicant's hand could potentially be justification for that extension grant.
Thank you. I'd like to move on to a different topic now, to appeals.
Yes.
So, Mr. Wrinkle, in your rebuttal testimony on page 2, you testify, and this is responding to Oxy's proposal, that an appeals process is already incorporated into the division's regulatory framework, which would be applicable to the proposed Class 6 program. Is that correct?
Correct.
And in your rebuttal testimony, you were referring to the procedures in 1915-48 NMAC, correct?
Yeah, I mean, I trust you. Let me look, but yeah, it is that referenced rule.
Do the proposed Class 6 rules specifically reference that provision?
No, I don't think so, and I don't really know if it needs to or not, but I do not think they point to that specific MAC.
Would the proposed Class 6 rules provide better regulatory clarity if they referenced that procedure or that provision?
I'm not sure. Possibly, but other rules that are out there as well where you can use that adjudicatory process. On that, I'm not sure if it would add any value or not.
Okay, thank you. Mr. Wrinkle, that's all the questions I have for you. Dr. Schnaar, is that right? Do I have that right?
Yes.
All right, thank you. Dr. Schnaar, I'd like to turn to some questions for you. I'd like to start by discussing the area of review reevaluation frequency. The federal standard for the area of review reevaluation frequency, that's at 40 CFR 146.84.84E, has two provisions addressing when a reevaluation must be performed, correct?
Yes.
First, there's a fixed frequency not to exceed 5 years, and then a second provision that is triggered when monitoring and operational conditions warrant. Is that fair?
Correct.
Yeah. I'd like to turn to that second provision of 146.84E. Is it your understanding that the provision when monitoring and operational conditions warrant generally encompasses situations when monitoring data and modeling predictions differ significantly?
Yes, and when operational conditions vary from what the permit had listed. So these are criteria that are defined in the project's area of review and corrective action plan.
So monitoring and that evaluation process is happening prior to the fixed frequency, kind of in the first provision. Is that correct?
If I understand the question, there may be instances where a reevaluation is triggered prior to the fixed frequency because of, as you said, monitoring data that doesn't comport with the modeling or other operational conditions that aren't exactly in line with the permit.
And OCD incorporated that second provision when monitoring and operational conditions warrant into the proposed rules, correct?
Yes.
Okay. But OC is proposing an area of review reevaluation schedule based on a fixed frequency that differs from the federal rule, correct?
Yes.
There's an initial reevaluation period, 2 years after injection begins, and then subsequent reevaluations not exceeding 4 years.
Yes.
What technical kind of sources did OCD rely on to decide on that 2-year initial reevaluation period?
In drafting the rules and working with OCD, the decision was made that at 2 years would be the first time that a practical time where there would be sufficient data and enough time to allow for a model evaluation. And in the team's experience, it was determined to be prudent to require a reevaluation at 2 years. But I will say that that reevaluation process, if everything lines up with your monitoring and your modeling, that reevaluation process may include just a demonstration that your existing modeling is sufficient. So it doesn't necessarily mean you need to change the model. It's just a formal time period to compare your modeling data and your monitoring data.
Given that subsurface geology is site-specific and injection rates may vary for a project, is it always true that the modeling can be verified within that 2-year period?
The team's decision was that 2 years would be enough time to collect pressure data. And although projects are different, there is a requirement for pressure data to be collected in the injection zone, and that 2 years of pressure data should be sufficient to compare to the model predictions.
Okay. Are you aware of any other states that have adopted an area of review reevaluation period as short as New Mexico is proposing?
There may be, but I'm not aware of one.
Okay. Thank you. Dr. Schnaar, I'd like to turn to another topic, groundwater monitoring. OCD is proposing to specify that groundwater monitoring must occur at a fixed quarterly frequency. Is that correct?
Yes.
What was the basis for selecting quarterly monitoring?
Quarterly monitoring is actually very common in groundwater monitoring compliance programs, and it's because there may be seasonal impacts. And so, and in practice, most CCS projects I've ever seen actually do perform that above confining zone groundwater monitoring quarterly. So it was based on those factors.
But the federal requirements prescribe it as periodic and kind of leave it up to the discretion of the agency to determine what's appropriate.
In some sense, but it is part of the initial permit application to define that periodic frequency. So it is subject to that agency's approval as part of the initial permit review.
By prescribing a specific frequency, would OCD have authority to vary the frequency based on either site-specific geology or the life of the project?
They would be able to, I believe, require something that would be more frequent, but not less frequent than quarterly.
Okay. Thank you, Dr. Schnaar. That's all the questions I have for you. Mr. Eales, I'd like to turn to you, if I may. I'd like to start by asking about the type of logs required by the proposed rule. The proposed rule requires resistivity, spontaneous potential, gamma ray, porosity, and fracture finder logs, correct? Mr. Eales, would you mind speaking more into the microphone? It's a little hard to hear.
There we go. That's correct.
Great. Thank you very much. Did you review the testimony from the Center for Biological Diversity, Dr. Helm Clark, recommending that spontaneous potential should be an optional log because newer logging methods provide better information?
Yes, I did.
Do you agree with Dr. Helm Clark that gamma ray logging supplemented by resistivity logging provides better information than spontaneous potential?
And on that one, I am not a logging expert as an SME. Where we stood on keeping it included was because it was a minimum requirement within Class 6 EPA. I would redirect that one to Dr. Wong.
Okay, thank you. Are you aware of concerns that spontaneous potential logs can increase the risk to well integrity?
No.
Did you review the testimony of OCC's witness, Ms. Wallace, raising that concern?
Yes, I did.
Okay. So did the division take those concerns about well integrity into account when it included spontaneous potential in the rule?
I would have to, again, direct that to Dr. Wong on his review of that. I'm not aware of that happening, no.
Okay. And then just my final question here. If alternative logging methods provide better information in a safer manner than required test, Does that make the rule less stringent than federal requirements?
I would say no to your question. So reiterate the question one more time, if you don't mind.
If alternative logging methods provide better information in a safer manner than a required test, does that make the rule less stringent than federal requirements?
You know, following your verbiage, if a logging suite provided better information, that makes it more stringent, more valuable.
Okay.
As long as it is covering the same expectations and requirements.
Thank you, Mr. Eales. That's all the questions I have for you. And Ms. Raney, I have no questions for you, so I'm done with the panel. Thank you very much.
Thank you, Mr. Tucker. Ms. Gutierrez, do you have any questions for Namoga?
Madam Hearing Officer, Ms. Gutierrez had to step away. Namoga has no questions for these witnesses. Thank you.
All right, thank you very much. Ms. O'Grady.
Thank you, Madam Hearing Officer. I will have questions for Dr. Schnaar and Mr. Eales. My co-counsel Rose Rushing will have questions directed at Mr. Wrinkle and Ms. Raney. And I will start us off with some questions for Dr. Schnaar.
I can't see you.
No worries.
There we go.
Yeah, we're all clustered up here. Starting with some questions about the PISC. What is the default post-injection site care duration in the proposed rule?
50 years.
And you testified about the division's proposal regarding a demonstration of a shorter alternative timeframe.
The proposed rule is identical to the federal rule in this case.
You testified during your summary of direct testimony that if a project is, for example, planning to inject for 5 years, the operator may be able to show that the pressures will dissipate fairly quickly and thus warrant a shorter PISC period, correct?
Yeah, that is correct.
You also testified back on slide 7 of your demonstrative that models, especially at the outset, will have some level of uncertainty.
That is true, but that is correct, yes.
Is it possible a shortened PISC period granted at the permitting stage could be based on data not yet tested with operations?
That is correct, but that is why, at the end of the day, one cannot end their monitoring during post-injection site care until they've made a non-endangerment demonstration. So the default PISC is a guide during the permit application phase, but it is not the final word on when the post-injection site care period ends.
What is the minimum period of time to which this period could be shortened as granted during the permitting phase?
There is no minimum time that is listed in the federal or the proposed New Mexico rule.
To your knowledge, has any Class 6 project in the United States completed post-injection site care?
No, I don't believe any Class 6 project has.
And again, to your knowledge, has any Class 6 project in the U.S. received site closure approval?
I think that might be the same question, but no, I don't believe that any project has.
Relatedly, you testified during your summary of direct testimony that after injection, the risks don't disappear immediately.
Yes, after injection ends, the risks are still present, which is why there is a post-injection site care period.
How long after injection ends does it take for the pressure to return to its original state?
Well, that's a very project-specific question, and it also is not the only measure of the potential risks. So it's not only looking at when the pressure returns to its baseline. There are other considerations, I would say.
Could the plume presumably keep moving while the pressure remains elevated after closure?
Yes, the non-endangerment demonstration and the alternative post-injection site care timeframe evaluation both include assessment of the plume migration and the pressure decline.
Would the monitoring continue until the plume has ceased migrating?
That is actually project specific, and there may be some cases where there's very minor movement, but this is covered in the EPA guidance, and it is a project specific determination of when that monitoring can end.
Thank you. Turning to the area of review and abandoned wells. You led portions of the federal rulemaking related to computational modeling.
That's correct.
Would you agree that reasonable modelers using the same data could produce materially different area of review boundaries?
Well, it's a fairly open-ended question, and I guess that circumstance could happen, and it's pretty typical for modelers to have some differences in their results, but I'd say I'm not sure exactly what you mean by materially.
You could have a different idea of what the area of review would be based on different modeling outcomes based on the same data?
Well, that might be, but again, I'm not sure if you're, minor differences versus significantly different answers. I would say I'm not sure I would agree that they would have remarkably different answers.
Would you agree that abandoned wells with incomplete records or inadequate plugging records, that they would require conservative evaluation?
Yes.
Does the rule presume that a well within the AOR lacking reliable plugging records is a potential conduit unless shown otherwise?
I think that is consistent with the general framework of the Class 6 program and the rules, yes.
And CO2 can be corrosive?
It can be, yes.
Does corrective action under the division's proposals require replugging of any existing penetrations with CO2 resistant cement?
I actually may kick that to Mr. Eales on plugging requirements.
Okay. Turning now to another topic. Your testimony does not address pore space, correct?
Maybe you could clarify what you mean by pore space.
Ownership of pore space, management of pore space.
That is correct.
Nor does it address unitization.
That is correct.
And the area of review is delineated by computational modeling of the plume and pressure front, right?
Yes.
But there's no fixed radius in the proposed rules about how far an AOR should extend.
That is correct.
So the AOR would be defined by geology, not by property boundaries.
Yes, and this is also identical to the federal rule in this case.
Yeah, I guess to jump ahead a little bit since you just identified that. So these rules really mirror the federal rules with some changes.
That was the intent, yes.
And there are certain portions of the regulatory regime that would be needed in New Mexico that are not in these rules.
No, I would not say that.
Did you hear the State Land Office's public comment? Oh, you would not say that, sorry.
You said there are, well, maybe repeat the question.
Are there pieces of a regulatory scheme that would be needed to permit projects in New Mexico that are not included in this rulemaking?
Well, when you say permit, I'll clarify. Do you mean Class 6 permit to construct and operate a Class 6 injection well?
Yes.
No, the intent of this rulemaking is for OCD to have oversight and the ability to permit Class 6 injection wells.
Did you hear the State Land Office's public comment yesterday highlighting some concerns about what is not included in this rulemaking?
Yes.
Once the EPA grants primacy, will the division start permitting projects?
Well, I may defer that to Mr. Wrinkle. I guess I also don't quite understand your question, but the intent is for OCD to have the permitting and the primacy authority to manage the Class 6 program.
And Mr. Wrinkle, please feel free to jump in here. I guess to clarify my question, will the division start permitting regardless of whether a subsequent rulemaking has been conducted to address missing or regulatory provisions that are not in this rulemaking that may be necessary to adequately permit a project in New Mexico? For example, unitization.
You know, I don't know if I'm really qualified to answer that, you know, being operational side of things. You know, if we are granted primacy after the EPA, you know, after this, the rules promulgated, EPA grants us primacy, then yeah, we will begin, you know, reviewing applications. And if anything comes up that is, I guess, chicken before the egg, right? You know, then we can incorporate that if that does happen.
Okay, thank you. Just to complete my questions from before, because I didn't invite Mr. Eales to answer, turning back to the question of CO2 being corrosive, would you agree that CO2 can be corrosive?
Yes, it can be.
And
Again, yes, it can be.
thank you. And does corrective action under the division's proposals require replugging of any existing penetrations within the AOR with CO2 resistant cement?
Yes, and let me add more to my first answer. So CO2 itself is not corrosive, but CO2 in water is corrosive. So there's a little variance there. And to answer your second, yes, 1915-43 EB requires the operator to identify all penetrations of any wells that are in the AOR and the materials those wells are made of and whether or not they're compatible with CO2.
Okay, thank you.
Yep.
And Mr. Eales, I'll turn to you now, actually.
Yep.
So I think we're all done with Dr. Schnaar for now. Thank you. Starting with emergency staffing, are you aware that Conservation Group's proposal regarding emergency staffing states the owner or operator must have, actually, let me back up. You testified in your rebuttal testimony, I believe, about Conservation Group's proposal regarding emergency staffing.
Yes, that's correct.
Okay. And are you aware that the proposal reads, the owner or operator must have at least one employee on the premises or otherwise available at all times with the authority to carry out the emergency and remedial response plan?
Yes.
So the proposal would require that either someone be on the premises or otherwise available.
Yes, that's correct.
So the requirement is not that there necessarily be someone on site.
That's correct.
Turning to automated shutdown systems, you discuss in your direct testimony the use of automated shutdown systems, yes?
That's correct, yes.
An automated shutdown system can detect anomalies and shut in a well?
Yes, it can.
Can an automated shutdown system assess whether a seismic event has opened a fault?
Yes, it can.
Can an automated shutdown system coordinate with emergency responders?
Yes.
Can it execute the judgment calls an emergency plan response requires?
It depends on how, how robust that system is, of course. So yes, it can in theory, but all scenarios being contemplated in advance would be difficult to program in an automated system.
Can an automated shutdown system fail?
Yes, it can.
If an automated shutdown system were to fail, approximately how long would it take to stop an unauthorized release of CO2, including the time needed to discover the source of the release?
That would depend upon the system. There's various systems that are in series as part of a protective defense. So each one would have a different mechanism or a different role to shut in.
Can you talk a little bit about what that would look like in a community or neighborhood, or perhaps in an extremely rural area like on Navajo Nation?
Yeah, so one of the protective systems is a subsurface safety valve that's referenced. That one actually has a lot of fail safes, so it can be actuated remote. It can also, just from a mechanical fail safe, just create basically a check valve. So if there was a problem, it would snap a check valve and stop any flow up from the well. The main thing that is very important with an injection well is they are inherently designed to inject into a formation that is more or less on a vacuum or very low pressure. So if injection stops, that's more or less stops the potential of coming back from the well. It's possible, but it's not a scenario of a producing well that has built up pressure. So from a community standpoint, there are the multiple barriers of protection in place, which are in place to kind of address what you're asking. And that is, yes, there could be one failure mode, but to have 2, 3, or 4 failure modes, they call it a Swiss cheese model. If you have multiple barriers, which we have in the standard, it's very unlikely that all would fail at one time.
And to clarify my earlier question, I should have asked areas adjacent to Navajo Nation that are rural, as of course this program would not regulate injection sites specifically on Navajo Nation. And you said it's very unlikely that all of these failure points would fail, but there is a possibility,
Always
correct?
a possibility, yes.
You stated in your summary of rebuttal that you oppose the Center for Biological Diversity's plans to require emergency response training mandates because you believe the proposed plan can be adapted by state and local responders?
Yes, and elaborating on that, the standard itself does have requirements to provide training to emergency responders, but the level of detail that was provided by CBD is what we found to be more into the area of what those responders' expertise is. So that was the reason, as the standard itself already has a requirement for that training that we felt was sufficient.
In your summary of rebuttal, you stated that you think mandatory peak ground velocity and peak ground acceleration thresholds are too rigid.
Oh, actually, I didn't say too rigid. What my response was the peak ground velocity, and those terms are very specific to seismometers and the seismic programs. And the New Mexico Bureau of Environmental Geology is the entity that specifies the level of quality and measurements that need to be taken to meet their standard. So the regulation specifies the requirement for a seismometer that meets the state's BEG's state's requirements. So it's not adverse to that as an idea, but that being outside of OCD scope.
You don't offer a justification for the use of other seismometrics instead, though? If I hear you correctly, you're just deferring to the OCD.
Yeah, to the BEG. Yep. And if you don't mind, on your earlier question that was diverted to me from Greg, the follow-up question I think you had was the materials and how you identify the materials to plug the wells. So just wanted to say that's also covered in the standard too. And it's in the same section I referred to as a subpoint below that.
That's all I have for you, Mr. Eales. Thank you.
Thank you.
Is that all for the panel?
I have, I'll do questions for Mrs. Raney and Mr. Wrinkle, if that's all right. Good morning or almost good afternoon, Commission. Thank you. And Ms. Raney, I'd like to start with directing some questions to you. Did you oversee the public outreach program throughout the development of the proposed rules?
The portions that I discussed in my testimony, yes.
Was the purpose of your testimony to demonstrate the required public outreach and community engagement that was conducted during development of these proposed rules?
Yes.
Regarding tribal consultation, you testified that you sent out 23 letters to tribes and ultimately had 2 meetings, one with Jicarilla Apache and one meeting with a representative of the Navajo Nation EPA, correct?
Correct.
Did you have any contact with the other 21 tribes?
In an official capacity under the Class 6 rule, under the guidance of OCD, not directly. However, informally, I engage with many of the pueblos and membership of other tribal nations on a routine basis where this is brought up in conversation.
Are any of those communications documented or a part of the record in this proceeding?
They were not requested to be, no.
Okay. So on the record, you sent 23 letters and met with 2 tribes. That's approximately a 9% contact rate. Is that successful tribal consultation in your opinion?
I would not necessarily equate it to the number of tribal nations that we communicated with. As I mentioned before in my testimony, the tribal nations that were contacted were primarily based on which ones would likely be eligible for a Class 6 project based on the geological information and location of the reservation of the Pueblo. So seeing as the Navajo Nation is one of the largest nations by land, that would be the priority, as well as the Jicarilla Apache. You also want to look at the background and the existing infrastructure of each nation. How far along would they be in that process? What would it take to get to an actual Class 6 project? The characterization, the amount of work involved, and the construction. It is a robust process, and Jicarilla Apache Nation has a well-established history of oil and gas operations and a very strong knowledge of the subsurface, as well as the Navajo Nation.
Okay. So you mentioned this robust process. Are you referring to just sort of your ongoing work with the PW or the PRRC, or is this about the Class 6 rule?
It's more the data that would be involved in doing an assessment for or scoping for a Class 6 project. So knowledge of the deep geology and those deep reservoirs where injection would occur. Unless you have oil and gas presence or data, it's rare to have that knowledge or any cores or well logs to that depth that would be taken.
Okay, so just to clarify, there wasn't formal consultation with 21 of the 23 tribes, but you are aware that some of the tribes may be impacted by Class 6 development, is what I'm hearing?
Objection, Ms. State's testimony. Ms. Raney testified. Ms. Raney testified that formal consultation letters were sent out. That is formal consultation. We can examine that in more detail, but the premise of the question stated